I had said that I would answer 5 of your questions about war stories, but it turns out there were a lot more questions and a lot of good ones, so I thought I would do this video response to the ones that we have. I'll start with Moses. Moses asks about permanent restraining orders. Permanent restraining orders can be overturned by a court that is higher up. So if you appeal to a higher court, they could certainly overturn a permanent restraining order. The restraining order itself wouldn't be declared unconstitutional because it would be issued by a court. Legislation gets declared unconstitutional. A court ruling gets overruled. So that would be my response to Moses' question. And let's see if I can scroll through the questions quickly. Altia asks if a restraining order can be expunged from a person's record. I'm not aware of that, to be honest, and I think that would relate to domestic violence orders. I don't know if those are maintained in a database somewhere. It could be simply a civil action. I'm not sure of that one, and I think it's a little bit beyond the scope of our course, so I can only give you an educated idea. I really don't know. Best time to consider a preliminary injunction when you have an action that will be irreparable. That is, you couldn't replace it with money damages or there would be serious consequences to it. So oftentimes there's no planning. It's something comes up and you have to act immediately. I've been asked also in a couple of postings about why such a short period of time. There's a couple short periods of time. One is that you may get a call that someone's going to go to a judge at 1 o'clock and it's 10 in the morning. That's not much time. The reason is because it's for emergencies. And if it's a real emergency, the judge will address it. If it's not a real emergency, the judge will tell you, we'll file a motion for this and ask for the court's relief, but that will give the other side certainly a lot more time. If a TRO is denied, you may be able to appeal that to a higher court. That would probably be the only alternative. If the judge has turned it down, they've turned it down. Good question by Sorabel. She says, what if you haven't notified the other side? I can tell you that in, I think, all of the TROs I've been involved in, the very first question will be, have you notified your adversary? In, I think, almost all the cases, but not all, my adversary was there at the court, so we had obviously notified them. In one instance, we did have to swear that we had sent them a fax and that we had sent them telephone notice of an appearance. Judges will ask that every time. They'll want some sworn indication that you've done that, so you can't be funny about that. You have to be truthful and it has to be accurate. Your reputation will be ruined if you misrepresent that somehow. If you couldn't, Lisa asks a good question, if you couldn't find the other party, if there's an emergency going on and you've taken all the necessary steps to let the party know, in other words, call and notify their business address, whatever, reasonable effort at notification, and you still can't notify them, and then there's an emergency that's going to happen, I think the court would enter the order anyway, and you'd have to proceed from there. Liz Lynch asks a question about how does it decide how the injunction is to be delivered. Generally, it's the way most likely for them to be given proper notice. So personal notice would be the very best way. If not personal notice, then probably taping something to their front door of their residence or taping something to a property where they conduct business. That would probably be next. But basically any way that's going to assure that they're notified. Marge asks about contempt hearings. Contempt hearings will oftentimes be given a little more time than you might with just a notice that you're going to go get a TRO. Sometimes the judge will want to give people a little more time. With a contempt hearing, people could be sent to jail. So a judge will want someone to possibly have the opportunity to get an attorney. Another question asked in here would be, what if someone couldn't get an attorney? That is, I call someone, say I'm going to go get an order, within a few hours. What if someone can't find an attorney? That's probably too bad. A court isn't going to delay something if it's an emergency, as long as you've had notice to it. Rick mentions the fact that, well, there's no notice, but maybe, or very little notice, but maybe you do get 10 days of the TRO only. That's true, and that's kind of the reasoning. That is, they would issue a TRO if you were able to make a good case for it. And the reason that they would was the idea that, well, it only lasts for 10 days, so perhaps you can take action after that 10 days. Oftentimes, by the way, some TROs will have language in there, and I've had the cases where if you got notice to people but they didn't reply or attend, judge would put a language in there that if they make a request to wipe out the TRO within usually 2 or 3 days notice, that would be some sort of relief for the other side if they felt like it had happened too quickly or they didn't get proper notice. But all good questions. If not notified in time, can they take advantage of it? Like I said, oftentimes in an order, if there's a question if they've been notified or got proper notice, court would indicate that they could oftentimes come within 2 or 3 days notice to ask that it be wiped out. Gang injunctions, I don't know whether California is the only state that does that or not. I've read articles that suggest it's a great way to do it, since it doesn't end up with being the typical merry-go-round of charging someone, then convicting them, then charging them the same thing. The idea is with an injunction, you could simply do it once, and then after that it would just be contempt hearings, which are a lot easier to do than charging someone and going through a whole new process. As I said, Sandy asked again about gang injunctions. Some people rave about it, but I thought someone also asked a really good question about how couldn't you use that abusively? And yes, you could. Carlos asked, do you need a voice recording of your notice to the other side? No, but you do need to submit a written certification. That is something where you could be punished if it wasn't true. So you're going to sign a document that says, yes, I gave them notice. So obviously you've got to be accurate. I don't know if other states, Kumo asks if other states done it. I do not know. Los Angeles, because it has, I guess, a large gang population, is the one that I'm aware of that has been most active in this area, and I don't know what other states are doing. Yes, Alexa's the one that asked, couldn't this be used in an abusive way? And yes, I think it could. It's designed to be a speedy way to punish or control a lot of people in their activities. And I could imagine it being used against groups that were dissenting or spouting unpopular opinions. If you recall, there was a religious group that was going to funerals of soldiers who had died in Iraq and were talking about how, making unpleasant comments that this was God's reward for, and then all sorts of things, homosexuality or other things that this church felt was true. And I believe they got an injunction against those people. That would be the most, kind of out there claim that I've seen, but I'm sure that it could be used abusively. Again, Rick's point about you don't get much notice, but maybe that's because the TRO is only good for 10 days. That's true. I'm recalling that one time I did get a TRO against someone to stop a sheriff's sale. And by issuing the order, it stopped the sale. And the other side was not happy about that because the sale had cost about, I think in a range of about $1,500 to bring it to the point of the sale, which they lost. So yes, there are some consequences to the other side when you do get one of these orders sometimes. And Amanda asks a question again about time, and I would say we've kind of addressed that, but that's very true. Oftentimes people may not have enough time to get an attorney. The courts believe that because the TRO is only 10 days, maybe that's not such a big problem. And that's it, everybody. That's my last reply. And thank you for all your questions. Thank you again. Bye.